Hello and welcome to Raider HQ After Dark. I'm your host Raider. And in this video, before we get started, I'd like to take some time to just recognize the fact that the channel in 3 months has gotten up to 6,000 subscribers, which is actually, from what my kids tell me, pretty darn amazing. So thank you all for that because, honestly, we couldn't get here without a veteran, a family member, a VSO, whomever, liking and subscribing the videos. So I appreciate that. Thank you so much. And we're just going to keep kind of the trajectory that the channel has for just putting out, fairly solid content consistently. We're just going to keep that going. So if you are watching my videos and you haven't liked and subscribed, and you're not my ex-girlfriend who's not liking my channel, then you know what? Feel free to hit that like button and do all the YouTubey things. I'm older, so I don't know what that means, but do it. My kids say to tell you to do that, so here we are. Now, let's get to the video. Today I wanted to kind of talk to you guys about case law again. And I know this is a spicy one for a lot of you guys, but I just want to get into kind of talking about how to determine when the VA itself has applied the case law. I also want to talk about a recent case law because I watched a video about it, and the YouTuber's interpretation of it was fine. It was fair, but it wasn't actually accurate to how the VA behaves. So I wanted to kind of break that down and discuss that, and then discuss potentially how the VA is going to circumvent the case law. So let's get started into it and share my screen, and we'll make this big. So how you go about determining whether or not the VBA itself is applying that particular case law in rating your claim. How do you determine that? Now, before I do that, the BVA, the Board of Veterans Appeals, works drastically different. It's like night and day. So when a case law goes into effect, the following day, the BVA can use that precedent set by, like, let's say Ingram v. Collins, and they can make legal determinations based upon it the next day, even, after it's been, officially, released and whatnot. The VBA is not like that. The VBA itself takes time because the VSRs, RVSRs, and authorizers are not legal scholars. Some of them have GEDs. Let's be honest. So what happens is that the precedent gets given to the VBA's legal team, legal counsel, whatever, their QRT teams, all of that nonsense. And it filters down through. What they do is they take all the legalese and they take it and they just kind of translate it into operational procedure, or as it's commonly known, the M21 manual. And the M21 manual is how the VSRs, RVSRs, and authorizers, that's their playbook. The legal team has translated the case law into no, you do this. And that's how you satisfy Mitchell v. so-and-so. So going back to this, how do you determine whether or not case law is being applied, even though it's filtered by the VA, whether or not it's even being applied? Well, you just go here to the M21 manual, va.gov, no VA benefits type thing, and you just type it in, Ingram. And then you look at your search results and you're like, wait a minute, there's nothing here. Well, then that means that Ingram v. Collins is not yet in the pipeline for the VSR, RVSR, and authorizer to actually utilize it in any of your claims. So this is the point where I'm going to come over here and I'm going to say very important. Okay. If your claim hinges, if the outcome of your claim hinges on a case law being liberally or literally interpreted, then you might try your first process of going through the VA, which will likely get denied because there's no case law currently for it, or potentially there is, but the VA filtered it to the point that they're not following the actual case law. I would do a appeal to the board because the board looks at the raw case and applies legal precedents in the raw law. So that's if your claim is hinges on the literal interpretation of the law, then that's going to be your avenue that you likely want to go to. Now, I am not a legal person, so you might want to consult legal counsel on that to see, because once again, the manual is what's most important to the raider. So you would, like that's outside of my knowledge base. I've never dealt with the law, law. So, but if we look here at Mitchell, like let's say, okay, well, Mitchell. Okay, here you can see it. You can see a lot of entries where Mitchell v. Shinseki. You've actually got the case law being cited in the specific manual references. That's how you can determine whether or not it's in play. So that's just a little bit of important information for you. Now let's move on from there. So I had talked about this case law and kind of watching a YouTuber today about Ingram v. Collins. And basically what this case law did was it talked about musculoskeletal injuries and how, there's a process for range of motion, like determining range of motion. And there's a process even for flare-ups, right? Like you're not having a flare-up. It's for you to give an estimate during a flare-up of what your range of motion is. Now, keep in mind, if you give a range of motion, let's say you have neck strain, and you're like, oh, whenever I have a flare up, I have 0.0000000 range of motion, all zeros. The examiner has the liberty to go, okay, medically, that doesn't make any sense. There is no, unless you got hit by a car during your flare up, there is no way on earth and under heaven that you have 0.0000000 range of motion during a quote flare up. It's not your diagnosis should not ever manifest that symptom if that's the only diagnosis you have. So the examiners have the ability to overturn your subjective statements about your range of motion. They can say, look, this is what he said, but I'm going to put these down. And they have to medically kind of explain it a little bit. So what this decision did is it talks about medications. If you're on medications, it can make it to where you have a more extended range of motion, to where you have less pain. If you're guarding your musculoskeletal injury and it prevents you from fully, having a fuller range of motion, then that makes sense. So what happens here is Ingram sued, and I'm using a lot of general liberties here of explaining this, so don't kill the messenger. I even got one of those. Don't kill the messenger on this one. So we're using this generally. So what Ingram said was, hey, look, yes, I'm on medication right now, but because I'm on medication, you don't see the full scope of my limitation of range of motion. Now, the YouTuber that I was watching was explaining this as if medication, you can now use medication, if you're taking any kind of pain medication, you can now estimate your particular range of motion and say, like you do with flare-ups, and just be like, yeah, I'm on pain meds, but if I wasn't on pain meds, it would be 0.0000000. Okay, but that's not actually factually the case as to how Ingram actually won this case, in my opinion. Now, this is just my opinion. And the reason why Ingram won this case is because if you come down here and if you control F and you find, no, it's not that. If you find physical, and if it'll work, yeah. Ingram actually had physical therapy notes that showed a limitation of flexion for his back. So this was competing evidence. So even though his back was really good during the examination, he had physical evidence in his treatment records that showed the limitation of flexion, and that his presentation at the examination was better than these physical therapy session notes because of the pain meds. Now, I'm just going to tell you up front that as long as these physical therapy notes were within a year of the claim, there's no reason why we shouldn't have just taken this particular percentage right here and just went with that. But that boils down to, and this is going to be kind of a segue, this boils down to the fact that the VSR and the rater would have to read every single page. Because I'm going to tell you right now, for range of motion in musculoskeletal conditions, it is actually rare for physical therapy notes or anything like that to give you a percent, like to give you an actual percentage. And they typically don't. They eyeball it, they ballpark it. But the problem here is that people, like, they want to see that oh, now I can just use medications, I can come up here and, well, I can come up here and now, like, because I'm using medications, I get to objectively state how limited my range of motion is. No, he got granted because he had evidence of it. But the one thing that Ingram appears to do is it appears to say, hey, look, VA and VA examiner, you can't just go off of your particular range of motion at the time of the examination. You also have to consider all evidence. And if there is evidence that there is worsened range of motion in the records, you should go with that, similar to a flare up. So here's what I'm going with this. I don't think Ingram's going to change anything. Because I don't think it's going to change anything for the VBA. And the reason why, and I know that I kind of talked about, I don't like to discuss case law until it gets filtered by the VA, because it's absolute speculation as to how the VA is going to discuss this. The only reason why I brought this video up is because I want you guys to understand why I look at this stuff and go, that's not a big deal. That's not going to change anything. Because what's going to happen is, and I can predict this pretty, I'm just going to, it's a prediction. So, you take that and 2 cents and you got 2 cents. But what's going to happen is, even though this is a big win, they're going to treat it like they treat everything else. So you're going to probably, like, either the VA is going to consider it like flare-ups, right? They might change, this might require them to have to change the DBQs, which would be annoying to say the least, to add a 3E section here for like non-medication limitations, right? And then it would just have another range of motion here. Well, you can already do the exact same thing with the flare-up section. Do you have flare-ups? Yes, I do. I have 60 out of whatever. Okay. Flare-ups are a medical process. So when it comes to raters, they will believe the flare-ups, and I know I don't want to say believe, but they will take the flare-ups at face value, because that's the examiner making a medical decision based upon the totality of the actual disorder. But with the medications, it's different, but it's not. I don't know. I don't see raters taking that at face value. They might go back. Now, why does that matter? Well, I have a couple manual references here. So, like, we're going to be probably using other manual references. So this is kind of the weird thing that the VA does, is that case law will come out and they'll say, yeah, you can, this now changes to this. Well, what the VA does is it uses other M21 references to restrict certain activities. So, like, if the Ingram v. Collins would actually invoke this particular manual reference right here, to where it says musculoskeletal examination reports containing self-evident contradictory findings, conclusions, and or terminology will also be rendered insufficient. Now, guys, this is I'm gonna take another tirade off the path here. This is one of the things that when you submit your private DBQs, this is how the VA just totally tears them apart. Because we can find them to be, insufficient if the examiner arbitrarily says that you have an unaffected gait and then you walk in with a cane. That's a contradiction, right? That's all it takes. It takes for your examiner, your private examiner, to make just an offhanded statement that contradicts other evidence found within the report. That's it. That's all it takes. I just wanted to say that. But the medication situation, like your limitation of range of motion and the medication situation will actually invoke this. So what will have to happen is we will have to have the examiner like testify that that limited range of motion could actually be within the scope. If you've got neck strain and you're like, I've got 0.00000, yeah, no, it's gonna, like, that right there would invoke this. And this is not a well clarified report. It just tells the rater, yeah, you can just find this to be insufficient. And the DRO would uphold this. All you have to do is cite the evidence. So I don't know. Like, but I want to circle back to this and just say, when the VA does introduce case law, they have to make it make sense with all the other regulations in the M21 manual. So, like, because what can happen is if you have a situation where you have contradictory manual references, well, that's just pandemonium, right? So the case law will not affect the majority of the manual. If the majority of the manual is leaning one way and the case law leans the other, then they will make the case law conform to the established M21. So, in my personal opinion, right, whenever you guys review the case law, like when you guys are looking at case law and how it's going to translate, when you guys do that initial translation, like you're like, oh, this is going to translate to that. That's the BVA. That's the way you're like, that's most veterans, they get it right in terms of how the BVA, the Board of Veterans Appeals, would interpret it. But when it comes to the VBA, no. I've even seen to a certain, like, you have situations like this, where you have pain. You should be able to report pain, right? Well, this particular manual references says that the veteran's subjective pain, right? Like, do not establish a compensable evaluation for a painful scar unless there is some objective indication supporting subjective reports of pain and tenderness. Okay. So what does that mean? That means that you can't just report that you have a painful scar. You have to show you have a painful scar. And I think that like, this is potentially another thing that could happen with, say, Ingram v. Collins, is that you have to prove, right? You're going to have to prove that you have range of motion in objective evidence. That's going to be the easiest way that the VA shuts down Ingram v. Collins, is that they make you have to show, similar to how Ingram did. He showed he had the limitation of range of motion at some point. You're going to have to do that. I don't think you can treat it like, I don't think you will be able to treat it like flare-ups, where you get to objectively just say what your range of motion is. Because he was granted by this judicial decision based upon the evidence of his limitation of flexion in physical therapy, it's going to have to, this was why he was granted. It wasn't because he said he had his pain, he didn't give a range of motion. It's because it was objectively reported. So I think that this could hurt veterans a lot more than it helps them. Okay. So here's my doom and gloom version of this. Ingram v. Collins could make it to where your flare-ups, you have to show medically where your range of motion is restricted to for the VBA. That would be the worst way that they could translate that to, but it is within their power to do so, right? That they put that additional caveat on here to where you have to show objective evidence of your flare-ups. You've got to go to the doctor and have a range of motion thing done at that time. So I don't understand sometimes why people celebrate case law. I mean, I can understand it when, you know, I can understand it when like when it changes something that can't be filtered, right? Like you have to include pain where pain was not included beforehand. Like that's a good thing. Like there's no real way to corrupt that. But the VA has to make this stuff work in the manual to where the staff members, everything's flowing in the right direction. It can't be conflicting. So I see case law, like people celebrate case law like it's a good thing, but sometimes it can be a horrible thing. And Ingram v. Collins has the potential. And this is why I don't like to speculate, is because I don't like to freak you guys out. But you need to, like, when a case law goes into effect, right? When we're searching for case law, when we're searching for Ingram, this is why I do those videos about, hey, the M21 manual is updated, because you need to see what it says. You can't just go, man, I read the Ingram v. Collins. Guys, we won. We won, guys. You can't do that because they will change it to however they want it to be. Like when you have flare-ups, now it's an estimate. But Ingram v. Collins could make it to where that estimate has to be reinforced with objective evidence. And it's fine. Like that's fine for them to do. The VA can do that all day long. There's no liberalizing law change. It doesn't require Congress. It doesn't require a new legal decision. They can just do that. Okay? Because right here, there's no case law here. There's no case law that said this. Okay? This is the VA made this determination, and they can do that. They can do that all day. So guys, that's about all I've got for you on this one today. I know that I'm going to be putting out more videos. I'm going to be putting out another answering the questions video here today. But just be careful with the case law. So I've at least taught you today how to determine when the VBA is actually utilizing case law. How can you tell that that's part of your claim process? So I did that. I did that with, searching here. I kind of showed you, how even though the case law that happens can matter for the BVA, the Board of Veterans Appeals, it doesn't necessarily translate exactly word for word over to the VBA and how the staff members do it. Save yourself a lot of anguish on this because they will never, the VBA staff will never do a word for word translation of, case law. Never. It's like absolute. I'm using the absolute. I hate absolutes. Never. A higher level review will never, ever use raw case law. You have to go into the M21. You have to actually, look to see how the VA holds itself accountable to the case law, because this breaks Mitchell, well, I don't think it breaks Mitchell because it's not a musculoskeletal, but there's different ways that like this, like where this was just made up by the VA. Like this is the VA's, oh yeah, this is what case law says. And then we're going to caveat it and say, like if we have contradictory findings, we can just disqualify everything, which is what they do. And that's why I say for you guys to double check your any kind of private DBQs you do to make sure that there's no conflicting annotations in there, in the history section, in the notes section, in the subjective statement section. You can't have that. Well, anyway, I have rambled enough. So I would like to once again thank everybody who's watching. Leave me a comment in here. I know that somebody's going to lose their mind about case law, and don't worry about it. I mean, look, it's like, meeting your hero and being disappointed, like the VA doesn't work like that. The VA doesn't work the way you think it does towards case law. It just doesn't. And there's no way to change that. Because in order to change it, you'd have to have every single person that works there be either a legal aid or an attorney or some kind of law judge or law clerk or something. And that's just not going to happen. But anyway, that's about all I got for you today. Raider out.